Good morning, everyone. I respect and welcome each one of you to this Advocate on Record Aspirants Academy. The academy is meant for what purpose? I must explain the purpose of this academy. Before that, let us see what is aspirant means. You all know what is Advocate on Record. Aspirant means one who is aspirant to achieve the goal, one who desires to achieve something. He is an aspirant. Academy, it's a school which trains such a person. So Advocate on Record Aspirant Academy, the purpose is to make every Advocate on Record aspirant to become a successful candidate and to come out with flying colors as an advocate on record. This is the purpose. And the second purpose is to dispel the ignorance of darkness and to light the lamp of knowledge. That is the second purpose. The third purpose is to make a strong bar. This sort of continuous education will make the strong bar. It will make an advocate efficient, and output of efficiency is effectiveness, and then in pursuit of excellence. So if we have a strong bar, we can achieve and effectively assist the Honorable Supreme Court or the other high courts or other district courts to render justice. Ultimately, the litigants are benefited out of efficiency and excellency of an advocate. That is the purpose of our academy. So whenever we start with a prayer. Generally in a government functions, they end by reciting national anthem, by praising our Mother India. In my humble opinion, if we say Mother India, who is our legendary father? Who is the father? The father is the Constitution of India. Reason is, father protects mother. So Constitution of India says about the territories of the India and citizens, their fundamental rights, fundamental duties, and it governs the entire country. That is why it is called as a supreme law and rule of law, and Constitution of India is sovereign. So therefore, for example, for Hindus, it is holy book is Bhagavad Gita. For Christians, the holy book is Bible. For Muslims, it is Holy Quran. But for Indians are concerned, it is the holy book is the Constitution of India, the legendary document and the living document, and it is a dynamic document. Reason is it grows with the changing time and it protects the fundamental rights of each citizens of this country. So as like how we praise our Mother India by reciting national anthem, we must praise our legendary father, and we are being a part of the judicial system, we must always recite the preamble of the Constitution of India as our daily prayer. There are reasons behind it. It is our fundamental duty to remember our forefathers and to bring that dream come true. So therefore, once we recite the preamble, it will get registered in our mind, and whenever we are drafting, whenever we are arguing, we must try to bring out the spirit of the Constitution that is enshrined in the preamble. So before going into the topic for today, I would like to recite the preamble. I request each one of our esteemed members to recite the preamble along with me. Thank you. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. So this should be our everyday prayer, dear friends. So with this noble thought, let us start our day. The day which we are beginning today, the topic would be introduction about the Advocate on Record examination. So first, before proceeding with what is Advocate on Record examination, we must understand what is the necessity for this examination. So to address this heading, I have framed 6 questions. First question is, what was the need to introduce Advocate on Record examination? What was the need to introduce Advocate on Record examination? Number 2, second question is, what are the eligibility criteria to become an Advocate on Record? What are the eligibility criteria to become an Advocate on Record? Number 3, what are the subjects for Advocate on Record examination? Number 3, what are the subjects that are prescribed for Advocate on Record examination? Fourth question is, how to read these subjects? How to read the prescribed subjects for AOR examination? Number 5, how to write the examination? Very important. We make preparation for the last 5 years, but how to deliver it? How to write the examination? Number 6, what is the result? What is the outcome of this preparation? So what is the outcome or what is the result of this AOR examination? So I framed these questions and I will make my endeavor to answer these questions. So let me move on to the first question, dear friends. What was the need to introduce Advocate on Record examination? The reason is, Advocate on Record examination is being conducted by the Honorable Supreme Court of India, and these Advocate on Records generally they practice in the Supreme Court. So the Honorable Supreme Court is the highest court of the land. If an advocate practicing in the district court and he deals with the case and the judgment is delivered, a judgment of the district court can be challenged before the Honorable High Court. So there is an appeal provision is there. If a judgment is delivered by the Honorable High Court of any states, you have an appeal before the Honorable Supreme Court. But once the Honorable Supreme Court delivers a judgment, Is there any appeal against the order of the Supreme Court? We can go for a review or a curative petition, but that has to be filed only before the Supreme Court. So, Supreme Court is the final arbiter of any decision. There is no further appeal at all. So, a person, an advocate who practices in the Honorable Supreme Court must know their responsibilities. When they are effectively assisting the Honorable Supreme Court, the Honorable judges is properly assisted and then they will render justice. So, effective assistance will have effective justice, speedy justice. So, for which the Honorable Supreme Court felt that we must introduce an examination called Advocate on Record examination. For what? For what purpose? Because they wanted the maturity. There are three reasons according to me. First, they wanted a person with maturity, because once a person comes out of the college, he may not know how to apply what he has studied in the college. So, at least it requires to see the practical aspects of law. So, it requires maturity, it requires experience. Therefore, a person must have at least 5 years experience. So, out of 5 years experience, he will get maturity, number one. Number two, second reason is responsibility, because an advocate must be responsible while dealing with his clients, while drafting a petition, filing the case within the limitation, arguing effectively before the Honorable Supreme Court. So, he must always endeavor to do speedy justice, assist to get speedy justice, which is also a part of Article 21 of the Constitution of India. So, he must be responsible. So, the responsibility flows from the maturity. And third reason is accountability. A person must be accountable to what he does. If his drafting is not good, if the SLP is not drafted properly, or it is not filed on time, who is responsible? Advocate on record is responsible. So, therefore, the Honorable Supreme Court in its wisdom strongly felt that a person with maturity, a person with responsibility, a person with accountability must be made when he is practicing in the Honorable Supreme Court. So, therefore, they have introduced a concept called Advocate on Record examination. So, this is the reason behind introducing this Advocate on Record examination, dear friends, in my humble opinion. Now, coming to the second question what I have framed, what are the eligibility criteria to become an advocate on record? For this question, we must go to the Constitution of India, dear friends. I already said our Mother India is governed by the Constitution of India. Any institutions, be it legislative, be it executive, be it judiciary, they derive their powers from where? From the Constitution of India. If any statutes are inconsistent with the provisions of the Constitution, more particularly the fundamental rights, they can be struck down. Article 13 of the Constitution of India says. So, any statutes that you read, you can always correlate with the fountain law, that is the Constitution of India. So, where to find out or trace out this advocate on record examination from the Constitution of India? Article 145 of the Constitution of India, it is rule making which empowers the Honorable Supreme Court to frame its own rules with respect to Supreme Court practice and procedure with the approval of the President of India. So, Article 145 of the Constitution of India empowers the Honorable Supreme Court to frame rules with respect to the Supreme Court practice and procedure. So, by virtue of Article 145, the Supreme Court framed the rules. That rule is called Supreme Court Rules 2013. That is what it is before you people. Supreme Court Rules 2013. This has come from Article 145, and this has got the approval of the President of India. So, in this Supreme Court rules, where do we find advocate on record? So, let me read, dear friends. There are 3 provisions that I will read for your quick reference. Rule 2(1) subclause A. Rule 2 subrule 1 clause A. Advocate means, this is where they define who is an advocate. Advocate means a person whose name is entered on the roll of advocates prepared and maintained by a state bar council under the Advocates Act 1961. So, this is a definition under 2(1)A of the Supreme Court rules. For the purpose of today's session, I emphasize on Rule 2 subrule 1(B), where it defines advocate on record. Very important. Advocate on record means an advocate who is entitled under these rules. Which rules? Supreme Court rules. To act as well as to plead for a party in the court. Important aspects are to act as well as to plead for a party in the court. So, an advocate on record is empowered, is authorized to act. Acting means to representing your client. So, how do you represent your client? Client will execute wakalatnama, empowering an advocate to represent on his behalf, on behalf of the client. So, wakalatnama can be executed by a client in favor of advocate on record only. He cannot execute wakalatnama to non-AOR. To an advocate it is not possible, to a senior advocate it is not possible, it is only possible only for an advocate on record. So, to act, so he will represent, advocate on record will represent his party, that is his client. And to plead, that means to argue the case, to plead his case before the Honorable Supreme Court, explain the grievance of their client and assist the Honorable Court to arrive at a justice. So, advocate on record is the one who is authorized to act and plead on behalf of a party in the court. Now, let me move on to one more section, dear friends, that is also very important. Q, senior advocate. Rule 2 subrule 1 Q, senior advocate. Senior advocate means any advocate so designated under subsection 2 of section 16 of the Advocates Act 1961, and all such advocates whose names were borne on the roll of the senior advocates of the court immediately before the commencement of chapter 3 of the Advocates Act 1961. So, for the definition of advocates and senior advocates, they are referring to the Advocates Act 1961. And most important aspect is Now you are all AOR aspirants. If you get a case today from some reference from the High Court lawyer or directly by the client, though you get a case, but you cannot file a case in your name. So an advocate requires the assistance of an advocate on record to be on wakalat. Similarly, when a senior advocate is engaged either by advocate or by advocate on record, a senior advocate must appear before the Honorable Supreme Court in the presence of advocate on record who has engaged him. So advocate requires the presence of advocate on record. Learned senior advocates requires the presence of assistance of advocate on record. But advocate on record, he can independently, he can act and plead from A to Z in the Honorable Supreme Court of India. So in my humble opinion, advocate on record is the heart and soul of the Honorable Supreme Court. So therefore, the advocate on record eligibility criteria is prescribed under Order 4, Rule 5 of the Supreme Court rules. This is very important. These are the eligibility criteria. Order 4, Rule 5 of the Supreme Court rules. Though there are several eligibility criteria are mentioned, I request each one of you to go through that. I will focus only on the main eligibility criteria. The main eligibility criteria is an advocate, his name must be on the roll of any state bar council continuously for a period of 4 years, minimum 4 years. You can have more than 4 years experience, no doubt about it, but minimum 4 years it requires on the date of commencement of his training. So 4 years experience as an advocate. How do you prove that? So you make an application to the concerned bar council where you have got enrolled, and then you ask for, you will make a request. Please have your seat. No problem. Yes, sit down. I am dealing with eligibility criteria, just sorted, so you have nothing missed. It is being video recorded also, so that will also be uploaded. So now I am dealing with eligibility criteria. What are the eligibility criteria to become an advocate on record? So the eligibility criteria is, he must have at least 4 years experience as an advocate. But how do you prove that? So you will ask for a continuity certificate to the concerned state bar council where you have got enrolled. And what would you state in the application? That you are going to appear for an advocate on record examination. Hence one of the eligibility criteria that requires is 4 years continuous practice. So therefore, for which purpose the state bar council can issue a continuity certificate. So you will prove by virtue of continuity certificate that you had minimum 4 years experience, number 1. Number 2, those 4 years experience must be completed on the date of commencement of your training. Commencement of training for a period of 1 year with an advocate on record who has completed 10 years standing as an advocate on record. So 4 years as an advocate, 1 year compulsory training with an advocate on record. Dear friends, this training, 1 year training, is not an empty formality by issuing a certificate for commencement and completion of training. Don't do that. This training is very, very crucial. The Honorable Supreme Court in its wisdom has kept this training as a very important aspect. So what sort of training that you get under an advocate on record? He is not an advocate on record, a fresher, or he is not having 2 years or 3 years experience. An advocate on record having at least 10 years experience, he will have the maturity, responsibility and number of cases also. So you can learn from those seniors. So first, what you will learn in a training period? Client approaches advocate on record. So you will understand how do you deal with your client. Client might tell you 1000 facts. Those may be irrelevant facts also or material facts also. How do you filter it? Your experience will come and help you in filtering what are the irrelevant facts and what are the relevant facts. So you learn how do you deal with the client. That is the first aspect in the training. Number 2, once you have heard the problems from the client, how do you address it? You will address to the court through a vehicle called drafting. So it may be a writ petition under Article 32 or Article 136. You will invoke extraordinary appellate jurisdiction by way of filing special leave petitions. Most number of cases are filed under this Article 136. So the most important aspect in drafting is also how do you draft special leave petition, civil or criminal or many other applications. So you learn drafting. Once it is drafted, what is the next stage? Will it remain at the lawyer's chamber? No, it has to travel from lawyer's chamber to the Honorable Supreme Court. Therefore, you will have a filing. It can be through online filing now or a physical filing. So you do the online filing. Once it is filed, it comes to the Supreme Court registry. The Supreme Court registry peruse your drafting. Is it as per the requirement of the Supreme Court rules? If there are any defects, they bring out all the defects. These are the defects, please cure it. That has to be cured, defect has to be cured by an advocate on record through a registered clerk. And then once it is cured, once the registry is satisfied with the petitions that it meets the requirements of Supreme Court rules, then it is listed before the Honorable Supreme Court. So from this, what you learn? You learn the filings, right? Thereafter, an advocate comes before the Honorable Supreme Court when a matter is listed for a fresh hearing, and time is very short during the hearing. So how do you address? What is the bullet point? What is the most important point that you would urge before the Honorable Supreme Court? Therefore, Honorable Supreme Court is convinced with your point, and then they are inclined to issue notice to the other side. So you will have to hit at bull's eye. How Arjun had towards the target of hitting bird's eye, likewise we must also hit at High Court order by saying this is where the grievance is within a short time. So you learn the art of advocacy by assisting the learned advocate on records. So once it is argued, judgment is delivered, then certified copy is to be applied and handed over to the client with collecting fees also. So you learn from the client counseling, from the how do you deal with the client, starts with C, ends with certified copy C. So C to C you will see everything. So that is very important. So without a training, without a teacher, they cannot learn on their own. So therefore, the training aspect is very, very important, and it cannot be an empty formality. It has to be very effective in pursuit of excellence, right? So 4 years plus 1 year is over. So 5 years is over for you. Now you are eligible to apply for an advocate on record examination. You will say, you will make an application to the Board of Examiners of the committee by saying, by producing continuity certificate and then by producing the commencement and completion of the certificate by which you are entitled to make an application for writing examination. So therefore, you are eligible to write advocate on record examination, dear friends. Questions will be followed after the end of the session, ma'am. Definitely we will love to answer. So after that, you have to clear the examination to become an advocate on record. So I have successfully covered what are the eligibility criteria to become an advocate on record. Now the next question that was framed is, what are the subjects? What are the subjects for advocate on record examination? We will go everything as per the Supreme Court rules, dear friends. Everything is mentioned here. So my endeavor is to take you, assist you, guide you to the relevant provisions, and you have to read on your own also, right? Now we have seen Order 4, Rule 5 of Supreme Court rules, where it prescribes the eligibility criteria. Now where is the subject? Where are the subjects mentioned? By virtue of Order 4, Rule 5 of Supreme Court rules, the Honorable Supreme Court has come out with the regulation also. That regulation called as Regulations regarding advocate on record examination. It is there. It is an appendix to this. It is a part of Supreme Court rules. It says, in pursuance of the provisions contained in Sub-Rule 1 of Rule 5 of Order 4 of Supreme Court Rules 2013, it prescribes the subjects. There are 4 subjects, dear friends. The first subject is practice and procedure of the Supreme Court. Practice and procedure of the Supreme Court. And they have given the syllabus also. The syllabus is, it deals with relevant provisions in the Constitution of India. Relevant provisions in the Constitution of India of relating to the jurisdiction of the court. So what is the jurisdiction of the court? If you see the Constitution of India, Chapter 4 of the Constitution deals with the Union Judiciary. From Article 124, where it prescribes about the establishment of Supreme Court, up to Article 147. So Article 124 to Article 147, it comes under the jurisdictions of the Supreme Court. It deals entirely with the Union Judiciary. Again, the syllabus in the practice and procedure is Supreme Court rules. This is what the Supreme Court rules 2013. Number 3, under the Supreme Court practice and procedure, the syllabus is relevant provisions of Civil Procedure Code. These are the syllabuses in practice and procedure. Limitation Act. Number 4, Limitation Act. Number 5, General Principles of Court Fees Act. So these are the portions covered under practice and procedure. This is what the regulation says. Let me move on to the next subject. Second subject is drafting. The regulation prescribes drafting in 2 parts. The first part is petitions for special leave, that is Article 136, special leave petition, and statements of case, etc. Etc. is very important because it covers many portions. The second part is decrees and orders, decree and orders and writs, etc. Number 3rd subject is advocacy and professional ethics, in which they have not prescribed the syllabus as far as the regulations are concerned. but that will come in the notification. When the AOR examination notification is out, they will prescribe what are the portions. So, to make a preparation, we can see the previous notification in which they have covered what are the portions for the advocacy and professional ethics. Even in the next classes, when we are dealing with each subject, I would be telling you what are the syllabuses, what are the entire portions that are covered under each subject. Today being an introductory session, I am just giving a brief idea. Number 4, leading cases. The Honorable Supreme Court has prescribed nearly 64 leading cases as far as 2024 notification was concerned. 64 leading cases where the Honorable Supreme Court has laid down a law for the entire country. So, what is the difference between a case law and a leading case law? When generally we file a case in the name of the parties, it is just a case law. Like Keshavananda Bharati versus State of Kerala, it was mere a case law. But how does a case law becomes a leading case law depends upon the substantial questions of law involved in that particular case. For instance, in Keshavananda Bharati case, one of the most important issue that was covered in that case was whether Article 368, which empowers the Parliament to amend the Constitution, can they amend the entire Constitution or subject to certain restrictions? So, what is the power of the Parliament to amend? To what extent they can amend the Constitution? That was a major issues. That was one of the major issues. And this case was decided by the Honorable Supreme Court comprising of 13 judges, one of the largest bench ever sat in our Indian judiciary, considering the importance of the issue involved. So, while arguing this case, the basic structure doctrine was put forth by the advocates. What is basic structure? They made a submission on behalf of the petitioners that the Parliament has power, of course, certainly has power to amend the Constitution, but without disturbing the basic structure. So, what is basic structure? We must understand that. The basic structure of a building, if we say, if you want to make renovation, we can change the color of the paint, we can change the floor, but we will not disturb the pillars, which makes the building to stand. Otherwise, once we disturb the pillars, then it will collapse. So, likewise, the Honorable Supreme Court has said, certainly Article 368 empowers the Parliament to amend the Constitution, but it cannot disturb the basic structure. But what is basic structure? Basic structure is, rule of law is a basic structure, separation of powers is a basic structure, federalism is a basic structure, and the list is exhaustive, and it will be dependent, it will be decided from facts to facts. So, Parliament cannot disturb the basic structure. So, this doctrine was propounded by through Keshavananda Bharati case. So, therefore, a case law became a leading case law for other cases to follow it. So, it is a guiding light. So, likewise, the Honorable Supreme Court has found nearly 64 judgments. If you carefully go through, dear friends, from the beginning we can understand how the Honorable Supreme Court has evolved from time to time, and how they have interpreted the basic fundamental law, that is the Constitution of India, with the changing time. Example, for one more instance is right to privacy in Justice Puttaswamy case. The question was whether right to privacy is a fundamental right or not. Where do you find right to privacy? It is enshrined in any of the fundamental rights? No. But the honorable judges, in their wisdom, they have said Right to privacy is a natural right, and it is implicit in Article 21. So, Article 21 has evolved with the interpretation by the Honorable Supreme Court judges to protect the citizens of this country. Therefore, they are honorably called as custodian of the Indian Constitution. So, these 64 cases we must read and enjoy. It is not a burden, it is a pleasure, and it must enlighten our knowledge. And in this leading cases, they provide, the examination committee will provide a book comprising of all the head notes, and it is an open book examination. So, they will provide a book to the candidates with the index, and you can find out the head notes of those 64 cases. But generally we presume that with the assistance of the textbook we can write that examination. No, it is just an aid to it. It may give some idea about the cases, but you are supposed to read the entire case laws. It must be there in your mind. If some provision is not there, if it is found in head notes, you can take a help. Otherwise, do not completely or solely depend upon the book that they provide. And where do you find all these 64 cases? It is already uploaded in the Supreme Court website. If you go to Supreme Court website, there is an option called home page is there, introduction about the judges are there. There is one more option called advocates, in which if you click on that button, it opens advocate on record examination. Again further you go into advocate on record examination, all the cases are beautifully uploaded with head notes, and the entire judgments are available, dear friends. So, just download it, and we will be dealing with each leading case laws in coming days. By virtue of this process, I will also update myself. So, it is a compulsive platform for me to read again and again, therefore, we can improve our knowledge together. It is a team spirit. Together each achieve more. The full form of team is together each achieve more. We want to achieve more and more in pursuit of excellence. Therefore, advocates will have effectiveness, efficiency, and excellent in their performance. Therefore, clients are also happy, courts are also happy, and this is like judicial academy. It is an advocates academy, advocate on record aspirants academy. So, we have successfully completed what are the 4 subjects, but where do we get these books? Where are the authors? So, for this I will share my personal experience, because there is no books prescribed specifically to my knowledge. So, I can share my personal experience how I have studied. For Supreme Court practice and procedure, I have studied Raju Ramachandran, done at Senior Counsel. The name of the book is B.R. Agarwala's. Now, I am moving on to this is the 4th question I framed, how to read advocate on record examination. So, for which I am addressing the 4th, I am giving an answer for the 4th question. How B.R. Agarwala's Supreme Court Practice and Procedure. This is the name of the book. B.R. Agarwala's.
Raju, can you just give that title?
Yeah. Title is Supreme Court Practice and Procedure. There are 2 authors. One is Raju Ramachandran, a learned and eminent senior counsel, and Mr. Gaurav Agarwal. He is also very recently designated senior advocate.
Gaurav.
Yes, Gaurav. So, once you purchase this book plus the Supreme Court Rules 2013 and any good commentaries on the Constitution of India, just that is maybe a reference book. D.D. Basu or any other MP Jain, whatever you feel like. That is only will assist you, but most focus would be on the Supreme Court practice and procedure.
What about HM Sirvai?
That is too long. You can always study HM Sirvai book. That is always good. That is lifelong preparation. For AOR preparation, Supreme Court practice and procedure by Mr. Raju Ramachandran, learned senior advocate, the book would be sufficient in my knowledge. If any portions are not covered, you can try to take other sources from other books also. So now it is a book. I will tell you, it is a book in front of us. How do you read it? I will just give you one example. For reading the book, you must have 5 years question papers downloaded. The last 5 years question papers, take a printout and keep it in front of you, and take out 2024 question first, and then whatever the, so you have taken 2024 practice and procedure questions in front of you, or 2023 the last. So once it is there, you will just mark whatever the questions that has appeared in the last year examination, you will mark those portions in the book. So you will put a cross mark. For example, first question is about writ petition. Explain writ petition under Article 32. So you will open the book, textbook in front of you, and you will just put a cross mark, and you will put a within a bracket 2024, that is the year in which it has come, -1. It may be a question number 1 or 2. So 2024 hyphen, it may be, if it appeared as question number 1, you will put 1. And thereafter, if next question talks about 136 special leave petition, you will go to the special leave petition in the textbook, you will just put again a question mark, sorry, cross mark, and then you will say 2024, it has appeared as a second question. So once this process is over, then you will take out the last to last year question paper, maybe 2023. Again you will see if something question is like writ petition is reappeared, you will put again cross mark, and you will put 2023, it has appeared as a sixth question. So once you complete 5 years questions and marking in the Supreme Court practice and procedure textbook, you will understand more number of cross marks or repeatedly asked questions. So this is how you will identify the important portions, right? So once you assess the last 5 years questions, you will have the importance about the important portions where the important questions are coming, and more number of questions you will give first preference and you will start studying, right? Second is drafting. Coming to the point, drafting. By virtue of your training under an AOR, you would have had experience of drafting special leave petitions, civil, criminal, IAs, interlocutory applications in civil cases, miscellaneous applications in criminal cases like application for exemption from surrendering, applications for condonation of delay in filing or refiling, exemption from filing as certified copy. So I personally, what I felt was, I did not purchase any book. I had a format before me, and by training I got all those drafting experience. But how to prepare for the examination, that I will deal it once I deal particularly about the drafting paper. Even I can give you one instance. Generally the drafting paper, in drafting paper they ask all the leading judgments passed very recently. For example, we are going to write in the 2025, the next year if you are going to write examination. So the examination generally is conducted in the month of June. So for 2025 you have to consider from July 2024, because exams got over in the month of June. So you begin with July 2024, and before the examination 2025, that is May, till May. So we will have 1 year the journey from
Including May or April? Or end of
okay,
April?
end of April. So from maybe May, June or July onwards, from July 2024 it goes up to April 2025. So the 1 year journey of the Honorable Supreme Court in its judgment. The most important subjects, most important judgments are asked by way of questions in the question paper.
Drafting paper.
Sorry, in the drafting paper. In the drafting paper, they would give you a important judgment decided very recently within the particular time what I have stated, and they will ask you to draft maybe SLP. Draft a SLP. They will give the entire facts with change of names, and they will be asked to draft a SLP or a suitable counter affidavit.
Nice.
Right? So once that question is asked, what you need to do is, you know what is that decided cases is, because a judgment is delivered, it is reported in the journal. What you need to do is go to the judgment, take it out, and while you are preparing, please always write down, dear friends. You put a tabular count. For example, I will give you an example, AOR judgment, if that has been delivered very recently. So you are asked to draft a SLP or a writ petition. So you have a judgment in front of you. So now you need to draft a petition. So you have to challenge the order. You have to find out the infirmities passed by the Honorable High Court judgment. So you will put a tabular column, submissions on behalf of the petitioners and submissions on behalf of the respondents. So in one page you have a tabular column having the submissions on behalf of the petitioner, the other column is submissions on behalf of the respondents. So in a judgment, they have always recorded the submissions on behalf of the petitioners, learned counsels for the petitioners submit so and so. So those grounds will be a grounds for drafting a SLP. So whatever the submissions made by the learned counsel for the petitioner in that case, please bring out all those points. At least you must have 15 points, minimum 15 points, because only when you prepare for 15 points you will deliver only 10 or 12 points, because we have a tendency to forget also because of the exam pressure and many aspects. So try to remember as many points as you can. So now it is ready, petition is ready. Now the counter affidavit, respondents submissions would be our submissions on behalf of the counter affidavit. So at one go, by reading a judgment, you will have a petition before you and counter affidavit before you. Right? Generally, the examiners would ask, confine yourself to the grounds and framing of substantial question of law. Generally, otherwise they will ask you to write the entire SLP also. We must be ready for everything, but SLP, that is questions of law and the grounds. So this is how you have to find out. So you have to keenly understand what are the latest judgments leading cases for the last 1 year that we would be dealing with in our academy also. So once we identified, then with the help of the seminars or the lecture series conducted by the Supreme Court registry itself, for every examination they allocate 2 learned senior counsels. They allocate 2 or 3 senior counsels for one subject. So before the examination they conduct lecture series, registry conducts lecture series. So they would highlight what are the important judgments. Yes ma'am, yes.
So last time, I mean,
Yes, yes.
my daughter was appearing, so I was practicing with her. They did not appoint these counsels till the very end. So like just 2 weeks before, 3 weeks before. That's not sufficient time, and those senior advocates did not mention which is important.
Yes.
We kept requesting, but this didn't happen.
Yes. See, we cannot make a request to these examiners boards what are the important questions, because I have seen very keenly all the 4 lecture series delivered by all those seniors, but virtue of our experience, we can cull out what are the important points. Because we had in our academy, we have dealt, and I have prepared a set of notes which is very, very important. So that we will do it. We will do it effectively, need not worry at all. So they will give an indication what are the important judgments. So our preparation should not depend only on their lecture. We have to follow it up for last 1 year, sorry, and then with the help of the lecture series. That is the drafting paper. Coming to the third subject, that is advocacy and professional ethics. In this subject, the notification 2024 notification prescribes the entire aspect of the syllabus. Evolution of legal profession. What are the duties of an advocate towards the court, client, colleagues? Whether an advocate can advertise in the social media, we are the best service provider, please come and approach us, 10% offer, Diwali offer. Can we do that? We can't do that. Or if a client does not pay you a fee, can you retain his brief? So there are, and what is contempt of court? What is misconduct? So everything is clearly described in professional ethics. Dear friends, the most important aspect for professional ethics, though we study in college also, why it is prescribed here? Taking a guidance from Dr. B.R. Ambedkar, he had said once in the Constituent Assembly, we have drafted the best constitution for India, suitable to our India, by taking out from the best provisions across the countries. But the best constitution may turn out to be worst if it is governed by bad people. Even the bad constitution may turn out to be good if it is governed by the good people. So the emphasis is not on the best or worst provisions contained in the constitution. The emphasis is on the good human being. How to become a good human being? What is a good human being? That was a question posed by King Yudhishthira when he was a child, one of the eldest sons of the Pandavas. He had asked his grandfather Bhishma, what is dharma? Bhishma responded by saying, it is very difficult to define what is dharma is, but I can explain you. Without harming others, helping others is dharma. Don't harm others. Helping other living creature is dharma. Upliftment of others is dharma. So therefore,
But dharma is meant your religious sacred duty.
the origin of justice, the origin of law comes from dharma. What is the motto of our Supreme Court? There is a motto, Yatho, what is that? Yatho dharma sthato jayah. Yatho dharma sthato jayah. What does it mean? It has come from Mahabharata. In Mahabharata, Duryodhana goes to his mother, Gandhari, to seek blessings. Gandhari says, she does not bless him with victory. Though son has come, she says, Yatho dharma sthato jayah. Where there is dharma, there is a victory. So in the war, where there is a dharma, victory lies with them. So that is why he was defeated. So therefore, dear friends, with respect to the third subject, that is professional ethics, emphasis on good human being, therefore this professional ethics is introduced. Number 4, leading cases. I told you the source also and how to write these papers. Now moving on to the 5th question. We have prepared enough resources there, books are there, we have identified what are the important points are there, we have done it. How to deliver it? We have read it. How to write the examination? That is very, very important. Because last 5 years experience you have to reflect within 3 years, sorry, within 3 hours. How do you do that? How do you project yourself that you are one of the best and sincere student? For writing any examination, irrespective of this examination, time management is most important. And we do not know a set of pattern of advocate on record examination changes from year to year. We do not know what is the pattern. So you must see how many questions are involved and how many questions you are asked to answer. Accordingly, you have to divide. Before writing your examination paper, you must have a schedule from 10 till whatever the examination starts. It's 3 hours, right? So you must see to that you complete the entire exam by 2 hours 45 minutes or 2 hours 50 minutes. You must have 10 minutes enough space for you to recheck. So you set yourself that 2 hours 50 minutes is the examination for you. So once you have the time management, how to write, it depends upon how much mark it carries. If it is 20 marks, you will be elaborating by giving synopsis, introduction, and the body of the answer deals with the particular question. For example, writ petition, again they are asking you to explain under article 32, 20 marks. So you will put synopsis and you will write introduction. The number 2, kinds of writ petitions. Number 3, you will deal in each detail of each petition, writ petitions, writ of habeas corpus, writ of mandamus, writ of certiorari, prohibition and quo warranto. You will deal with it, and you might deal each case law for each writs. It depends upon the marks. But how do you write it? You will write it by point wise, dear friends. Majority of the students write it in paragraphs. Nobody is interested in paragraphs, and examiners, they don't even have time. In writing points, you need not fill up the entire sentence, right? So writing bullet points point wise, that is very, very important. And how do you highlight it? Do we underline it at the end of the examination? The answer is no. Or do we underline for each word whenever we write? That is also no. What you do is you write first paper. Before going to the second page, you will understand what are the important points. You can underline that. And then go to the second page, write down, fill it up everything, write down everything. Before going to the third page, you underline the second with pencil, important points. So therefore, it is fresh in your memory. You cannot underline those important points at the end of the examination.
You underline the points in your answer script.
Yes, yes. In pencil, pencil. I generally did it in pencil.
You will have to pick up the pencil and give.
Whatever. But the underline must be neat and legible. And see to that whether, I don't know whether notification says that you cannot underline. I have not come across. That we will see as per the notification. And as well as we can ask from the examiners. They are the authorities. But in my case, I have underlined with pen and pencil. I did it. So this is how you have to present it. If it is 5 marks, means 5 points. If it is 10 marks, means 10 points. So something of this arrangement. You have to write it very neatly, legibly, and it must be precise and to the point. In the SLP, they have said very recently, the examiners have said you can frame only 2 questions of law, 3 questions of law, and 5 grounds is sufficient. In the last examination, the examiners, in drafting of SLP, candidates have asked a question, how many questions of law that we have to frame, how many grounds that we have to write. They said 2 or 3 questions of law would be sufficient, 5 or 6 grounds would be fine. Anyway, we are preparing 15 points as a ground, therefore we can easily write.
That's a beautiful way to do it.
Yes. So this is how you have to write, dear friends. Now coming to the final question, that is the result. What would be the outcome? If your preparation is good, if your training is the best, and you have this academy to assist you, guide you people, and every day it is a continuous education. We are not preparing for the examination, we are preparing for our entire life. So therefore, it is easily we can write down. We can easily write and always aim for gold medal. They provide 3 medals: gold, silver and bronze. So aim for something big that will make you big. Aim for gold medal, therefore you will not have the fear of losing the examination. Please, with this rich guidance, you can always aim for the best. There is nothing wrong in aiming for the best. Dr. APJ Abdul Kalam says that dreaming for small is a sin. Dream for something big. That is what he has said. So we will aim for gold medal. Now, what is the examination pattern is, it is for 100 marks each subject. And what is the minimum pass mark that requires is 50 marks, 50% in each subject, but aggregate has to be 60. So you must at least get 65 in one subject, 70 in one subject, therefore you will have the aggregate of 60. So 50 is the pass mark, but aggregate is 60. So there can be 3 options they have given certain in regulations. In regulation number 11 clause 1, it says when a person gets the aggregate of 60, a candidate writes his examination, the aggregate is 60, but he has failed in one paper. In one paper he is unable to get 50, he has secured for 49 or 40, but his aggregate is 60. So he has to write that one subject only in the next year, in the subsequent examination. So that liberty or concession has been given to that candidate.
In case 2 subjects.
Yeah, I will deal with that. I will deal with that. So this is only with one subject. So in one subject he has secured 40, but he has got the aggregate 60. Then he is entitled to write that one paper in the coming examination. There is yet another rule, regulation 11 clause 2 says that if a candidate gets 50 marks in all papers, he gets 50 marks, 50, 50, 50, 50. That means aggregate is also 50. He has not got the aggregate of 60. Then he has the option of choosing any one of the subjects. Any one of the subjects he can choose and he can write that examination to get the aggregate. This is regulation 11 clause 2 says.
But that may not be really realistic. If you've got 50, you have to get an overall average of 60, and in all the papers you've got 50, so in one paper you have to compensate for the remaining 3.
Yes.
So that means you have to get 10, 10, 10, 30 marks more,
Yes.
80%.
Yes.
Do people get 80%?
Yes, I have got 75. I mean, nowadays candidates are getting 80. They are getting it. With this guidance, definitely you will get it. Don't worry, don't worry about the marks. You will get gold medal. I wish and pray. Now let me move on to the next one. Regulation 11 clause 3. If a person fails in all the papers, then court will say that he cannot appear in the very next year. For example, in 2024, if he fails in all papers, he cannot appear in 2025, he has to appear in 2026, because it shows that his lack of preparation, lack of sincerity. Whatever you do, you must do it with dedication. Regulation 11 clause 4, what does it say? They prescribed maximum 5 attempts. They prescribed maximum 5 attempts. For example, you have appeared in 3 papers, you have not appeared in 1 paper, that also amounts to an attempt. So therefore, maximum 5 attempts, dear friends, but forget this 5 attempts. For our case is concerned, it is only 1 attempt and we are succeeding with good marks. That is our endeavor. So I wish, and I have answered all those 6 questions, right? So to sum up, we must do it effectively, and by enhancing our knowledge, when have a collectiveness, when have a people like this with the same spirit to achieve and to clear advocate and record examination, we can do it. We can do it, and our plan is to secure AOR gold medalist in the coming examinations. So with this, I am concluding the session for today, and I have given the entire introduction about the AOR examination. In the next Saturday, I would be dealing with practice and procedure. How do we deal with it? I have two options. One is we can go with the subject wise, or since we have identified the majority of portions, we can go with this more number of cross marks. We will deal with it first. So therefore, we can have a preparation towards the exam orientation. So thank you so much, dear friends, for your patience hearing. I am truly blessed and privileged to stand before you and to guide you and assist you in the AOR examination. Thank you so much. Thank you.